Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran. I am an employment lawyer at Samfiru Tumarkin, which is Canada's leading employee side employment law firm. That's me on the screen. I'm an associate at Samfiru Tumarkin. And I'm going to be your employment lawyer for the next half an hour, answering all your questions in employment law. Before we get started, let's just do a little bit of housekeeping. You can reach us if you need to at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855, I think was it 821-5900? I always forget. We'll see on the screen in 1 minute. We'll see if I'm correct. Well, it'll be on the screen in a minute. So while we're waiting for the questions, 821-5900. Okay, 1-855-821-5900. So you can reach us at either any of those methods of contacting us. Okay, questions should be rolling in any minute. Here's one right now. Question from Neil. A group of disgruntled employees at my workplace want to resign and start a competitive business. Okay. There will likely be negative effects for our current employer. Does starting up a competitor leave us liable for anything? We don't have a formal contract or any form of non-compete. Sure. So you're really asking a question about restraint of trade clauses. Restraint of trade clauses come in two forms. You've highlighted one, which is a non-compete clause in your employment contract. Another is a non-solicit clause. So a non-compete clause says that you can't go and work for a different employer who is competitive in your space. Those tend to be presumptively, I'm not going to go as far as saying presumptively unenforceable, but if you spent your whole life making widgets, your whole working life making widgets, and then your employer, and then your employer fires you, and all you know how to do is make widgets, and you've got a mortgage and 3 kids, if you're not allowed to make widgets for 2 years, that can be a real problem financially for your family. And so the law understands that and says, generally speaking, those are going to be unenforceable. There are certain narrow contexts where it can be enforceable, usually for people who are C-suite employees and up, who are privileged to or privy to insider information or important, we'll say, information to the company. And if the clause itself has to be narrowly defined in scope, so it can't be geographically in North America. It would have to be to a limited region, and it would have to be temporally limited. However, non-solicits are a different animal. Non-solicits are presumptively enforceable. Non-solicit agreements, solicitation agreements, or clauses effectively say you can't poach former employees or clients of your former employer for a specific amount of time. Again, broadness questions come into play if a clause is too broad or encompasses non-clients, such as potential clients that have been marketed to. The clause could fail then. But the spirit of a non-solicit is that it is enforceable, or that generally speaking, it's a reasonable thing for an employer to say, hey, you can't poach our clients and your former colleagues for a period of time. So if you have one of those in your contract, then you have to be aware of it, and certainly you want to get legal advice on that. The question is, however, you're starting up a competitive business, which will take clients from your former employer. Does it leave you liable for anything? Well, I mean, I think that depending on how serious the loss is for your former employer, I'm sure that they'll probably bring some sort of suit against you and argue that you had either some sort of fiduciary duty to the former employer or something. But whether or not you're liable is not something I can answer. Well, number one, it's actually slightly outside of my scope of expertise, and two, it's just impossible to answer that question without reviewing in great detail various facts, or sorry, the elements of what's going on here. I think that you need to talk to an employment. I think you need to talk to a lawyer right away. I don't necessarily think an employment lawyer. Yeah, I mean the lawsuit itself isn't going to be. Sorry, if you incur liability, it's not going to be pursuant to any restraint of trade clause in your contract. So I'm the remedy for your former employer, if you guys do this, is going to be outside of sort of the traditional scope of employment law. And it may be that you want to talk to a lawyer who specializes a little bit in the remedies that they'd be pursuing, such as unjust enrichment, and perhaps breach of fiduciary duty. So I know that doesn't answer your question, Neil, but I think that you need to talk to a lawyer about that before you guys do it. I think it's important to be armed with the knowledge that you need to have with respect to risk, um, on starting a competitive business that's going to probably result in some sort of legal action. However, generally speaking, without a contract that limits you to or prohibits you from solicitation, poaching former clients, uh, you know, it puts you in a better position. Okay, moving on. Tony asks, can an employer fire you for a mistake that other employees have not been fired for? That's a great question. So your employer can fire you for anything. Um, I mean, it's just what is your remedy? If they fire you for a human rights protected ground, that would certainly be a problem. If you got fired because of your ethnicity, for example, that would be a substantial issue for that employer. Um, but generally speaking, your employer can fire you at any time. Your only legal right in the event of your termination is severance. Now, severance can be, depending on the nature of your employment contract, and your length of service, um, your position, and what you do. It can be quite lucrative. Some people get as much as 24 months of severance. The question that you're really asking, or at least that's implied in your question, is can they fire you for just cause and pay you zero? And I don't know if that's what's occurred here with you, Tony, but generally speaking, if at least in BC, there's law on this point. If your employer fires you for just cause, so the capital punishment of employment law, pays you zero, fires you for conduct that is also being committed by other employees who are not being fired, and everybody knows that this conduct is occurring for the people who are not fired, you have an argument that the employer condoned the actions, your actions, because everyone was allowed to engage in the same actions. And so, certainly, if that was the fact pattern, I would certainly take you on as a client. So I hope that answers your question. But there's not enough information to go on in your question, so I'm kind of inferring what your question is. But yes, if it's a known thing that other employees are engaging in the same conduct, they can't just inconsistently enforce that with respect to just cause. Can they fire you and pay you severance? Yeah, absolutely. So it really depends on your situation. But I do think, Tony, you should talk to an employment lawyer right away. You need to talk to us. You can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, Raj asks, Raj prepared his own severance demand letter to his employer, citing the common law inducement and Bardall factors. Okay, good research there. If the employer doesn't respond with my demand or to my demand, what should I do next? Sue them or negotiate? Okay, so generally speaking, Raj, I'll say a layperson, so a non-lawyer, does not have access to our legal system in the same way that a lawyer does. Okay, And also, generally speaking, employers don't give you the money that you want or that is commensurate with your, well, we'll just say they don't give you more money out of the goodness of their heart. They have to, lawyers, because they can access the legal system in a way that you can't, represent the threat of future financial pain. And that threat is, hey, you better pay Raj this money, because if you don't, not only am I going to go to court and get that money, you're going to have to pay your own lawyer $50,000 or $60,000 just for the privilege to pay Raj the money he should have gotten. So the employer looks at it as both the cost of the legal fees it's going to incur plus the amount they're going to have to pay out. And so, because of that threat of future financial pain that the employee's lawyer represents, uh, employers will negotiate with lawyers at a much higher level than employees themselves can get. So I'm not saying that you won't get what you've asked for, but generally speaking, that's what I've found. Employees can say whatever they want, the employers won't budge, or they'll budge a tiny bit. So that's number one. Number two, employment law is incredibly complicated. You're talking about inducement. Inducement is very complicated, and you have to meet a whole bunch of factors in order to get it made out. More importantly, we don't know if you're entitled to the common law. We don't know if what your employment contract says. It's so complex. And if you're talking about suing them yourself, absent legal advice from an employment lawyer, I have concerns generally for anyone who says that to me, that they might actually harm their legal position by not having legal advice. So, Raj, I mean, if I have a client and I make a demand for money from an employer and the employer says, no, we're not giving you any money, generally speaking, the next thing I do is I file a lawsuit in the appropriate jurisdiction. Depending on the nature of the facts and issue. But I strongly recommend, before you do anything like that, with one huge caveat. Sorry, the caveat is you have 2 years, generally speaking, from the date of the termination to file an action in court. If you're running up against that, you need to file something immediately, because if you exceed the limitation period, you have no claim. It's just gone, and you have no entitlement to anything. Okay, and that's statutory. So, with that caveat aside, I think that you should get legal advice. I strongly think you should get legal advice before you do anything. So, again, if you want to reach us, you can do that. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thanks, Raj. Oh, Raj again. How much time and costs? How much time does it take, and what does it cost on average to sue an employer and employee? And I think it means employer in superior court. I plan to self-represent. Any downside of self-representation? Yeah, I just gave you the downside of self-representation. The only caveat I'll say to that is, if your matter falls into the small claims cap, different in each province. In BC, it's $35,000. I think in Alberta, it just got changed to 100. I think that might be correct. I'm not familiar with what it is in Ontario. Generally speaking, small claims courts are structured, so not superior court, the court level down, are designed to help or to be accessible, or more easily accessible by lay litigants. And so, that might be something that you find to be, depending on where your dollar figure of your potential best day severance claim lies, it might be attractive to you. How much time does it take? Well, it depends on which forum. If you're going into small claims versus superior court, depends the kind of defense that's being mounted by the employer. Depends on if you fall under accelerated rules such as fast track in British Columbia. There's just, it depends on discovery. It's impossible to answer that question. But things tend to slow down in litigation if you have the ability to negotiate before litigation, it might be something that is advantageous to you. But again, Raji, I strongly recommend you get legal advice before you pursue anything else. My employer terminated me for unauthorized absences, but every time I called in, I spoke to a manager, which is the protocol. My union has been ignoring me. Should I get an employment lawyer? So actually what you need is a labor lawyer. I know these distinctions are not familiar to those not in the employment bar, but if you are a member of a union and are subject to a collective bargaining agreement, you need to talk to your union rep. If your union rep is ignoring you, there are some lawyers who represent union side employees who are not having success with their own union. I certainly can't refer you to any. I mean, I could refer you to one in BC maybe, but there aren't very many of them. But that's who you'd need to speak to. We can't assist here with your particular question. I will say though, generally speaking, when you talk about calling in sick, medical leaves, absences, you want a paper trail you can point to later. Even if you make a phone call to your manager, I would paper it afterwards and send them an email just confirming our conversation on X, at this time on this date, where I've informed you that I can't come in today because I'm sick, or whatever it is that you're going to say, or whatever the nature of the medical leave is or the absence is. But that way, if there's a dispute, you can always go through. Your record after the fact. I can say there'd be all kinds of, if you're an individual employee, as opposed to part of a collective bargaining agreement, there's all kinds of ways to attack what it is that you said. But I unfortunately do not have the expertise to comment on your matter, given the fact that you are subject to a collective bargaining agreement. Okay, Sam asks, my employer is talking about a vaccine requirements for the winter due to the COVID resurgence. That's an interesting question. Has there been anything definitive about whether or not they can force this on employees? So, no. There was a decision in BC last year which held that, a Superior Court decision in BC last year, which held that vaccine policies by employers were reasonable, and that in the instance of putting an employee on an unpaid leave, not terminating them, it was reasonable for the employer to do that. It is unclear across Canada, due to the nature of this decision and the lack of decisions anywhere else from any Superior Court, whether or not a just cause termination is for failing to comply to a mandatory vaccine policy, is something that was legal. It's not clear at all about that, but certainly in the case of unpaid leaves, at least in BC, but likely across Canada, given that was the only legal decision we have, they are reasonable and are certainly upheld. Now, the question you're asking is if there's a vaccine requirement for the winter, i.e., do you have to get boosters or do you have to get vaccinated for the first time or something like that? The BC decision I referenced talks about this was the best medical information we had at the time. I think that that's a live question that I can't really answer, and I think it is ultimately going to be, considering that the state has now backed off of vaccine mandates entirely, except for in public health settings, and I think some government settings. I think that would be a tough one from your employer to do. But again, if they fire you, and then you're left with a risky action after the fact. So I think that it depends on your setting to a large degree. If your setting is, if you work in a hospital, for example, yeah, you're going to have to get it. It's the same as, there's been lots of law across Canada on flu shots, for example, and do hospital workers have to get flu shots? And the answer is yes. So if you work in a public health setting and there's a vaccine requirement, I suspect that you're going to have to follow whatever the requirement is. If you're not, though, um, I don't. I think that's an open question. I think that I think we don't know. I think we don't know, and I think the answer is to some degree more political than it is legal. Even though I know that doesn't help you, and it doesn't help it doesn't answer your question. I try to work it out with your employer if you're strongly opposed. Um, that would be the best solution. But as of right now, I don't think we have anything concrete. I was terminated in June. However, I feel that my termination was unjustified. Is it too late for me to talk to a lawyer? No. You've got, generally speaking, 2 years from the date of the termination to file an action in court, after which time you don't have a claim anymore. And then if you have a human rights component to your claim, so if you were fired because of your ethnicity or a medical leave, a disability or something like that, you've got 1 year in BC. I don't know about other provinces. I think there is some consistency about it, though, but you've got 1 year to file a human rights complaint. And then, of course, if you have an employment standards complaint, you've got different limitation periods across Canada. So no, if it's June of this year, it's not too late. I want to point to, or just talk about your language, though, about termination was unjustified. Well, it doesn't, whether or not you feel that it was justified or not doesn't determine whether it has value. The value comes from whether or not you were not provided enough notice or pay in lieu of notice as commensurate with what the law says you get, given what your employment contract says, your position, your age, and your length of service, generally speaking. And so if they fired you without paying you anything, so they fired you for just cause, then you have a question about whether or not termination, capital punishment of employment law, firing you with paying you zero severance, whether or not that was justified at law. But if you got severance, the question is, did you get enough? And if you didn't, that's just wrongful. That's a wrongful dismissal. So I think, I don't know your name, but I think you should talk to an employmentlawyer.ca. We certainly are in Alberta. If you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Anita asks, I'm currently fighting to get what is owed to me from my former employer. My question is, I was entitled as part of my employment letter to a yearly bonus, but I have yet to be given that from last year. Can I also fight for this? Thank you. Well, it depends on what your contract says. I have had and continue to have, let me phrase that differently. I have had certainly clients where they haven't had an employment contract, and part of their compensation was in the form of a bonus that they got for the duration of their employment, such that we argued that it was an implied term of their wages, and therefore the employer couldn't just choose for its own gain to not pay the bonus that they had paid throughout the employee's history. That certainly works if there's no employment contract. If there is one, it can be more complicated. But yeah, you may absolutely have an entitlement to it, and certainly that's certainly I've had clients with that exact same entitlement in the past. So again, you may want to talk to us. I'll give you the information at the end. Just want to get through these last few questions. But certainly you should talk to an employment lawyer about that. And if you have an employment contract, then whether or not you're entitled to it will depend on what's in the four corners of your employment contract about that particular bonus. And if it's silent on it, it depends how long you've been there for, how many years you got the bonus for, and what the fluctuation was. Like if you got zero some years, and then some years you got $20,000, it was inconsistent, probably out of luck. So Donna asks, is there a time limit for wrongful dismissal? Yes. We just talked about it, but I'll say it again. It's 2 years from the date of your termination, right? And so wrongful dismissal just means you didn't get enough notice and or severance. Okay, so that's what wrongful dismissal means. Is there a time limit for wrongful dismissal? I was let go in February. No verbal or written warnings, but health matters arose within family members could not do anything. They gave severance, but still have not spent it. They seem to be doing this to a lot of employees. Yeah, so I think you need to talk to an employment lawyer about a couple of things. Well, first question though is, did you sign a release of liability in exchange for the money? Because if you did, you have no claim. I mean, you might be able to make an argument if you signed the release the day you were terminated and you didn't get an opportunity to consult to get legal advice, then maybe you can argue that it was unconscionable, that the bargain you made was unconscionable, but you have an uphill battle to some degree, because you've been given something, money, in exchange for signing a release. So that's my first question. Assuming you didn't sign one though, if you were let go in February, you have two things to get legal advice about. One is, do you have a wrongful dismissal claim, i.e., did you not get enough severance? Second one is, do you have a human rights complaint because your family situation required you to? Well, actually, I don't quite understand your point here. So, health matters arose within family could not do anything. I don't know if you were dismissed because of your family matters or partially dismissed because of your family matters, or you just, due to the family situation, weren't able to pursue your wrongful dismissal claim. So if it's the former, you're going to want to ask the employment lawyer if you have a human rights claim, and if it's not, then certainly you're within time to bring your wrongful dismissal action. But you should talk to an employment lawyer right away. Nima asks, offered 2 weeks severance if I sign a release after my termination of 2.5 years of employment. Didn't sign the release and was given the severance, negotiating my severance now. Next steps. Well, I mean, if you are provincially regulated, you should have been given the 2 weeks anyway, because you were there for 2.5 years. So, a release in exchange for that is nothing. They paid you the 2 weeks. Great. Now you're arguing about common law. I mean, it depends on what you were making, whether or not it makes sense for you to get a lawyer involved. If you were making 150 grand a year, then yes, absolutely, you should talk to an employment lawyer right away. If you're making 40 grand a year, then you can still talk to an employment lawyer. But if they paid you 2 weeks, you should. I mean, you're there for 2.5 years. Employment lawyer can get that up to 3 months or something like that. And potentially, depending on your situation. So, you should talk to an employment lawyer. I would do that. But if you're negotiating on your own, as I said earlier, it's an uphill battle against employers who generally don't bend until a lawyer's involved. How much more do we have? Okay, I can get through these. I don't know this person's name. I'm asking due to I was not paid severance and I was there for 8 years and want to see about that. This is the person we talked to in Alberta before felt that his termination or her termination was unjustified. If you're not paid severance, then you were fired for just cause. You should absolutely talk to an employment lawyer right away, Alberta person. And I'll give you the information right at the end. MJ asks, how many years can we go back to the employer for an unjustified termination? Thank you. As I said earlier, you all have limitation period questions today. Generally speaking, it's 2 years from the date of termination in every province in Canada. So you've got 2 years from the date of termination to file an action, after which time you're out of luck. You have no claim. And same person asks about a performance improvement plan. Are we obliged to sign it? What are the options? The best we can do. Thank you very much. I mean, you can sign it, or let me rephrase it. You can sign it or refuse to sign it. I don't think it has any bearing on anything, other than you don't agree with it. Performance improvement plan is a tough place to be. It's your employer basically saying, hey, it's the end of the road. We're trying to paper this so we can get rid of you for just cause and pay you zero, more or less. And then they're going to put in items that they want you to hit in order to improve your performance, to meet their conduct and or performance expectations. If you get a PIP almost always it's a precursor to firing you. It sometimes employees can meet the objectives of the PIP and stay on, but really the employer is just doing that most of the time, in my experience, to pay um, to as a precursor to getting to terminating you. Um, I think PIPs are, the question is, can they fire you for just cause and pay you zero? You don't meet the requirements of the PIP, and they've provided you with other clear. Because the core of just cause, at least for ongoing performance issues, is they provided you clear warning of your performance failure and an opportunity to correct it. That's what the PIP is doing. But a lot of performance improvement plans, PIPs, I feel aren't going to get that job done for the employer, because they use a shotgun approach. Here's 50 things that we don't like about this employee, and if they don't improve all of them, then we're going to fire them. And I mean, that's just that's not anything. That's not something actionable that the employee can work on. It's just a generalized complaint. But if it's one thing or two things, like employee is constantly half an hour late, and then you don't fix it, then it puts you in a worse position. So when you've been provided a performance improvement plan, your options are limited. Generally speaking, you have to work hard to meet the terms of the improvement plan, or depending on your situation and your job, you might want to look around for another job. You might want to use that time, the PIP time, while you've got 4 months to try to meet the objectives of the performance improvement plan. Find somewhere else to go to work, because they're going to boot you out anyway at some point. But maybe you want to see if you can get severance on the other end of the PIP if they're going to get rid of you. But once you've got a performance improvement plan in hand, it's a tough road for you after that. It's generally speaking, it can, and I'm not saying in your specific circumstances, and I've certainly seen it with employees and clients who have got one of them and then made changes to their performance and then continued to be successful at the employer. But the PIP is for the employer's benefit, not for yours. So it's almost, for most people, it's hard to continue long term after the PIP. So I'll leave it there, and I thank you for all the great questions. I will, if you need to reach us, you can do so again at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. You can join us for the next live session with Martin Willemps. He'll probably get mad at me for the way I said his last name. Martin is just a genius with disability law, and he'll be here 10 a.m. on October 17th answering all your questions about disability law. You definitely want to join us for that. Great. Well, thank you for all your wonderful questions. Have a wonderful and safe weekend, and I'll see you again in 2 weeks.